Hatcher. I am the regulatory law judge presiding over today's hearing. The commission has set this time aside for an evidentiary hearing in the general rate case of Confluence Rivers Utility Operating Company. This is case number WR-2023-0006. We'll go ahead and start the proceedings with introduction of counsel. We'll start with Confluence Rivers.
Good morning, Your Honor. Appearing on behalf of Confluence Rivers Utility Operating Company are Russ Mitten and David Woodsmall.
Thank you. And for staff?
Morning, Judge. For the staff of the commission, Kevin Thompson, Post Office Box 360, Jefferson City, Missouri, 65101. Various other of staff counsel attorneys will be appearing during this hearing. Thank you.
Thank you. And for ease of the court reporter, that reminds me, not just staff, but also for the company, as we have other attorneys come up to speak, if they could spell their first and last name the first time that they come up. For the Office of the Public Counsel.
John Kleiser. Do I need to spell my name?
No, I'm sorry. I meant as the attorneys who have not introduced themselves. Mr. Thompson was referencing some of the other staff counsel that will be rotating in.
John Kleiser on behalf of the Missouri Office of the Public Counsel. My contact information is with the court reporter.
Thank you. And a quick announcement for those on WebEx and those listening to the live stream. The parties have reached a partial settlement. I'm informed that this involves 11 issues. 2 of those issues were on today's calendar. Today's calendar had included 4 issues, which is recommended reports, uncollectible expense, rate case expense, and income taxes. Uncollectible expense and rate case expense are among the issues that have been settled. Therefore, the parties have informed me prior to our opening that they intend to go forward with opening statements and then the presentation and witnesses for recommended reports and then income taxes. Another quick announcement we do have an agenda meeting for the commissioners scheduled today that begins at noon. Therefore, this proceeding will be taking a recess at 11:30. That'll allow technical staff to arrange their setup and for everyone involved to make their way upstairs. That will be an extra long break, depending on how far we get this morning. If we need to come back this afternoon, I'm thinking until 2 o'clock. The main reason is the agenda meeting starts at noon. There is a presentation by another utility company that will be occurring at agenda. And then I do need to provide some time for the commissioners to eat. So I am right now envisioning a break of 11:30 to 2. We will circle back at 11:25 or so to nail down and make sure that everyone agrees and understands to that. Last announcement on exhibits. I have traditionally given the parties 1 week from the last day of the hearing to turn in any exhibits that get requested to be late filed, or any exhibits that the parties are going to be introducing during the hearing that are not yet prepared or not yet on the exhibit list. So I intend to make that August 24th. That's the Thursday following the 17th. Yes.
Turn in, do we just submit those to the court reporter? Do we put those ourselves in the U.S.? How do you want that situated?
We changed our procedures during COVID, and I have not fully changed back. I'm not going to let the parties fail. What I'm looking for is I will turn in all of the pre-filed testimony. If it's an EFIS, the judge will take responsibility for marking and turning that in. The documents that I need you all to turn in, and that can be printed copy to me, normal course of business during the hearing. That can be as a normal course of business during the hearing, the commission finds it wants some information. And one of the parties says, we have that, but we're going to need some time to get that together. I normally just put all of that in a kitchen sink and call it due a week after, because that fits in nicely with the 10 business days for the order to do the transcription. Excellent. That is all the announcements I have. Before we go to opening statements, are there any issues to bring up? Mr. Kleiser?
Really quick, I had anticipated that we would have many openings before selective issues. Is that consistent with how the commission? I'm seeing you nod your head, so.
Yes. For the record, the judge agrees. That has been the practice as far as I've been involved in the last however many hearings that have multiple issues. That's fine with me. Are there any objections for many openings? Excellent. So granted.
No, nothing further.
Okay, let's get to opening statements. Confluence Rivers, please go ahead.
Thank you, Your Honor. I have a PowerPoint that's up on the screen. Yes, just initially, you may hit this box. Eric Rocchio is one of our regular. If you get it to where the
I highly doubt that, Mr. Woodsmall. However, while you are handing out your presentation, I would like to state for the record the attendance of the following commissioners: Commissioner Glenn Kolkmeyer, Commissioner Jason Holzman, Commissioner Kayla Hahn, and we will be joined by Commissioner Maida Coleman in mere seconds. Is the chairman on WebEx? Okay. Go ahead, Mr. Woodsmall, with your Confluence opening statement.
Thank you, Your Honor, and good morning, Commissioners. David Woodsmall on behalf of Confluence Rivers Utility Operating Company. It's nice to see you all again. Throughout my 30 years of practice before the Missouri Public Service Commission, I've noticed that oftentimes attorneys, including myself, fail to present their cases and issues with any consideration of the big picture. Attorneys fall into the trap of single-minded focus on the intricacies and nuances of their issues. That type of approach, however, does a disservice to you as the commission. You see, in my mind, commissioners are supposed to do more. The commission is supposed to be judging issues in light of the bigger policy issues, in light of the bigger picture, in light of how you want utilities to proceed in Missouri. The commission is supposed to see the bigger picture, and I'm supposed to tell you our view of the bigger picture. As I'm going to show you in a bit, Missouri has an overwhelming problem with thousands of small, distressed water and wastewater systems. Probably more than any other case in the past 30 years, this case provides the commission the opportunity to assess this mammoth problem. Second, to create policy goals targeting this problem. And third, to consider how its rate-making decisions on issues presented will affect those policy goals. Throughout this case, you will be inevitably asked to decide several issues. Your job, however, is to go much further, as I mentioned. So while the commission will be asked to decide whether a cost is a repair expense or a capitalized investment, I ask you not to decide that issue in a vacuum. In fact, please don't decide any issue with blinders on. Instead, I'm going to repeatedly ask you to decide the issues in this case with a view towards that bigger picture. Since most of you have never heard of Confluence River, or before this case may not have heard of Confluence River, since you've never heard a rate case involving a predominantly sewer company, and given Confluence River's novel business model, we have a lot to tell you today. So fasten your seatbelts. Here you see a list of the topics that I'm going to discuss today. We'll talk about the bigger picture that I just referred to, not only on a national level, but that bigger picture on a Missouri state-specific level. I will then discuss the Confluence River business model. Finally, I'll go through some of the larger issues in this case. Moving on to the topic of contents that shows the national big picture. Let's start with a discussion of that national big picture. This video will show on a national level the problems with deteriorated water assets and the lack of capital to fix those assets. Importantly, this is all firsthand information. These are all systems among the 850 that CSWR owns. These are all systems that we own, that we've rehabilitated.
We expect to breathe clean air, to play safely in the streams and lakes around us, and turn on our taps and safely drink the water that comes out. But we have more than 50,000 public water systems and 35,000 wastewater systems serving communities across our country. That's right. Many of these systems, that are an essential part of our everyday lives, have been in operation for more than a half century, often without any investment whatsoever. They lack the staff, expertise, and funds to address critical water safety, reliability, quality standards that so many Americans depend on. This has created a quiet crisis for small communities across the U.S. that are plagued by inadequate water and wastewater services. In fact, 1 in 4 Americans drinking water comes from untested or contaminated systems. 1 in 4. And yet, despite this lack of investment and care, water, when you think about it, is critical to our economy, to our health, and to our way of life. Just maybe one of the few things that unites all Americans today. Our dependence on water and the infrastructure that connects, protects, and supports it. Hundreds of thousands of Americans face realities such as home drinking water that is filled with contaminants like E. coli and lead, streams and lakes in public parks that contain untreated human waste, and children playing on playgrounds near ponds of sewage. And consider this. On average, annually since 2015, there have been 80,000 violations of the Safe Drinking Water Act. Some 70% of the overall violations and half of the health-based violations occurred in systems serving fewer than 500 people. This means our smallest, most vulnerable communities are the ones at the greatest risk of consuming drinking water with dangerous contaminants. And that's unacceptable. The mission is clear. Change must occur. Much needed improvements are on the way, but the infrastructure crisis for small water and wastewater is not looming. It's here today.
So how did this problem come about? It has been decades in the making. A Wall Street Journal article talking about the crisis of confidence in America's tap water. Because of the size of the United States and the way in which land has developed, the water and wastewater industry has become incredibly fragmented. Unlike electric service, which developed through federal programs involving rural electrification, governmental entities like the TVA, as well as the merger and interconnection of large electric utilities, water and wastewater services developed in more of an ad hoc, a one-off basis. Developers have developed land and constructed houses and subdivisions, and in order to provide the necessary services so they could sell those homes, the developers developed the water and wastewater systems. So the developers put in sewer mains, water mains, drinking water facilities, wastewater treatment plants. So unlike electric service, individual subdivisions and communities may all have their own water and wastewater services. This is exactly the situation you've seen down at the Lake of the Ozarks. Dozens and dozens of small water and wastewater systems that are not interconnected in any way, run by different owners and different managers. As a result of this ad hoc development, the water and wastewater industry in the United States has become incredibly fragmented. Today, according to Bluefield Research, a utility research agency, there are over 70,000 water utilities in the United States. To put that in perspective, blue field indicates that there are only 11 such utilities in England. 70,000 versus 11. Incredibly fragmented. But just because an industry is fragmented, however, does not mean that it must necessarily be characterized by distressed systems. Why did that happen? Why are these systems so distressed? As I mentioned, these water systems were often installed by developers. But we all know that while they install these utility systems, these developers are really not interested in operating a water utility. They want to be developers of subdivisions. They want to build houses. They want to make money and get gone. Recognizing that no one will buy a house that doesn't have water and sewer service, however, the water system became a necessary evil to their overall goal of building the subdivision. Once the subdivision is complete, however, the real dilemma begins. What to do with the water utility? In some cases, the developer will continue to operate the utility as a regulated utility subject to your supervision. In other cases, the developer will turn that water utility over to the homeowners association. In other cases, the developer will just simply walk away. Not my problem anymore. This is the beginning of the death spiral that we have seen far too many times in the United States and in Missouri. Whether owned by the developer or the homeowners association, that water and wastewater system is now set up for inevitable failure. The system is not professionally operated and managed. How many homeowners associations do you think know how to operate a water and wastewater system? How many homeowners associations do you know that know how to determine the need for system aeration or the need for and the timing for the pumping of sludge out of the plant? How many homeowners associations do you think know how to address a wastewater system that has had its biological activity wiped out because someone flushed paint thinner down the toilet? Beyond these operational necessities, the water system owner, whether it's a developer or an HOA, also doesn't know how to take proper sampling. Furthermore, the owner is not aware of increasingly stringent changes in effluent limits promulgated by the EPA. The owner is not aware of operational process improvements that could be made to meet those effluent standards. Moreover, the owner doesn't know how to maintain the system. How many of these owners do you think know how to grease or maintain a blower, an aerator, or a lift station, or why they need to crawl down into a lift station? Given the lack of technical expertise, the system is further set up to fail. Eventually, after failing to submit samples or operating the system in a professional manner, the DNR becomes involved. Now the trouble really starts. DNR begins taking samples of their own. DNR begins sending notices of non-compliance. For a regulated system, the owner may want to make improvements to address the problem, but they don't know how to pursue a rate case in Missouri. They don't know that they have to front the capital to make improvements before they can get it into rates. They don't know where to find the capital to make those improvements so that they can then get it into rates. The death spiral just keeps spinning. Without being able to front the money, the owner is also not permitted to seek a rate increase. Now you see the downside of a utility with a lack of financial capability. Ultimately, the owner will throw their arms up in frustration. DNR will now have the Attorney General move in and take action against the system. Or the Public Service Commission, as it often has, will seek to have the system placed into a state-supervised receivership. Or perhaps, without DNR or Public Service Commission even knowing about it, the owner will now walk away, unable to figure their way out of this death spiral. Now the state has a problem, but not just the state. You have a problem. See, Public Service Commission is the entity that people look to guarantee they're getting safe and adequate service. So when all this happens, what are you going to do to meet these assurances? This is the bigger picture underlying the existence of CSWR as well as the issues in this case. So let's talk about the bigger picture in Missouri. How big is this problem in Missouri? It's huge. While there are 70,000 community-based water and wastewater systems in the United States, a disproportionate number of those are located in Missouri. 4,500 of these community-based water systems in Missouri, almost 6.5%. Just on a pure state level, you'd expect to see 2%. Missouri has 6.5% of these. Of those 4,513 community-based systems in Missouri, almost 2,900 have experienced non-compliance in the past 3 years. In fact, according to the EPA's ECHO database, almost half of all drinking water systems have had non-compliance in the last 3 years. Worse still, almost 71% of the wastewater systems have been in a state of non-compliance over that same period. Despite the almost overwhelming nature of these statistics, other than to acknowledge Confluence River's mission statement, staff and public counsel make essentially no reference to this bigger picture. Staff and public counsel do not even recognize in their testimony of the biggest sewer case you will ever hear of this overarching problem. They don't say how their issues in this case reflect that problem, how the issues in the case and their positions may help to solve this problem. How do staff and public counsel propose to address this problem? They don't, and they never have. Who does propose to fix this problem? Confluence Rivers. In 2015, Hillcrest Utility Operating Company, one of the Confluence River predecessor companies, purchased its first system. Now known as Hillcrest, this system is located in Cape Girardeau County and serves approximately 250 water and wastewater customers. A description of the condition of that system should be very familiar for you by now, since it would be repeated in dozens and dozens of subsequent applications for acquisition. The Hillcrest system was under a pending AG enforcement action associated with the existence of pathogens in the drinking water. In fact, that system had just, when it was purchased, was under a month-long boil water boil order. Reflecting the death spiral that I just talked about, the previous owner indicated he didn't have the capital to put in the necessary chlorination to treat the presence of pathogens. He didn't have the capital, his responsibility, he didn't have the capital to put in chlorination. And because he didn't have the capital, he couldn't get the rates to do it either. The death spiral. The system also lacked adequate storage or backup power. Similarly, the Hillcrest sewer system was under an AG enforcement action as well and was discharging pathogens into the local waterways that kids were playing in. Consistent with the death spiral I just discussed, at the time of its purchase, Hillcrest system had not had a rate increase in 35 years. Reflecting its lack of understanding of the big picture, as well as its role as the constant obstacle towards anybody trying to attack this problem, public counsel questioned whether Hillcrest in its acquisition had the technical, managerial, or financial capability to operate this system. Instead, they preferred the status quo. Ultimately, the commission approved this acquisition based upon a non-unanimous stipulation between the company and staff, but public counsel refused to support. It's become a constant theme in Missouri. Confluence Rivers then purchased and fixed systems elsewhere, and public counsel stood in the way. In 2017, another Confluence River predecessor company, Elm Hills Utility Operating Company, sought to purchase the Missouri Utilities water and wastewater system. At that time, Missouri Utilities had been under a court-supervised receivership for almost 20 years. Again, the commission approved a non-unanimous stipulation between the company and staff, but public counsel refused to support it. Again, the status quo was better to them. Again, in 2018, Elm Hills sought to purchase the Twin Oaks system. And again, public counsel raised impediments. All told, Elm Hills made several more acquisitions of non-compliant water and wastewater systems. Almost without failure, public counsel raised concerns and obstacles. And despite public counsel's concerns, the commission approved those acquisitions. So not only is public counsel seemingly incapable of recognizing the bigger problem here, it's also incapable of presenting any type of solutions. But worse still, when a solution is placed in front of them, they're incapable of seeing it. Today, Elm Hill systems are back in a state of compliance and providing environmentally friendly utility service.
Decade. Residents of the Twin Oaks, Rainbow Acres, State Park Village, and Shriners Golf Course communities in central Missouri with unsafe and non-compliant and wastewater systems. But starting in 2018, Central States Water Resources, Elm Hills Utility Operating Company, purchased these hazardous systems and, working with the state of Missouri and other stakeholders, initiated an overhaul to ensure for safe, reliable, and environmentally responsible water resources. As Homeowners Association, the wastewater system in the Twin Oaks community was struggling. Its recirculating sand filtration bed exceeded effluent limits set by the Missouri Department of Natural Resources, resulting in harmful contaminants being discharged into a waterway, causing serious harm to residents and wildlife. As often is the case, the Homeowners Association did not have the technical, managerial, or financial capabilities to upgrade the wastewater system. Elm Hills acquired the system and took immediate action to protect the community, adding a moving bed bioreactor aerobic treatment system to ensure it met effluent limits, among other repairs. These upgrades provided Twin Oaks with a safe and environmentally compliant wastewater system, protecting the safety and environmental health of the community. Rainbow Acres was another underperforming wastewater system run by a homeowners association. Consisting of a 3-cell lagoon that did not meet state limits for basic wastewater treatment, the system routinely overflowed, had structurally unsound berms created by muskrat infestation, and was non-compliant with Missouri effluent limits. The collection system was also constructed of vitrified clay pipe, which was cracked, causing extensive inflow and infiltration, sanitary sewer overflows, and backups in residents' homes. Elm Hills stepped in and acquired the system. Lagoon berms were repaired. A moving bed bioreactor aerobic treatment system was added so the system could meet effluent limits, and much needed repairs were made to the sewer collection system to prevent backups and overflows. These upgrades and repairs brought peace of mind and environmental safety to Rainbow Acres residents. Missouri Utilities was a privately owned water and wastewater utility that had been in receivership for over a decade, meaning it had been taken over by the state of Missouri due to a complete ownership failure. Thus, with little oversight, the utility's drinking water and wastewater systems serving the Shriners Golf Course community were dangerously at risk. The drinking water was tied to an unreliable well, and there was no backup system. Ground storage tank, which was a rail tanker car, was found to have 4 inches of rust sludge in it, which not only posed health risks to residents, but also was reported by homeowners to be ruining household appliances. The community water system was in such poor condition that at one point, when a well failed, leaving the community without water service, the residents took up a collection to restore water service as the prior system owner was unresponsive. Elm Hills acquired the system and invested in reconstructing the well, tying in an emergency backup water supply to the nearby city of Sedalia, and refurbishing, sandblasting, and painting the water tank both inside and out to ensure for safe and reliable fresh water storage. At the same time, residents would routinely find raw sewage spilling onto the community golf course, rainwater flooding basements, and environmentally harmful contaminants entering public waters. New bioreactors and ultraviolet disinfection technologies were added to further stabilize the community's utilities. Cited by the state for countless public safety violations, including a 2,000-foot sludge blanket that formed in a nearby recreational waterway in Missouri's Knob Noster State Park, and pathogen-laden waste discharging into public waters with direct public access, State Park Village's wastewater system was severely overloaded. It served double its intended capacity and had unreliable lift stations that were highly unsafe, exposing local families to dangerous contaminants. With public health at stake, Elm Hills installed new power panels and security fencing at lift stations, constructed a new tank allowing for proper moderation of wastewater, reconstituted the entire wastewater treatment process to minimum state standards, and installed a UV treatment system to process E. coli out of the wastewater, and more. Transforming water utilities by using technology and innovation to quickly assess and invest in reliable infrastructure that meets or exceeds stringent state and federal safety standards. That's Central States Water Resources and Elm Hills Utility Operating Company. These revitalized water systems have dramatically improved the health, safety, environmental sustainability, and well-being of the residents of Twin Oaks, Rainbow Acres, State Park Village, and Shriners Golf Course, who can now count on clean, safe, and reliable water resources for generations to come.
So before I move on, one of the things that's not said there is the implications of Confluence River coming in and buying these systems. Some of these systems were under moratoriums. Some of these systems were so bad that federal lending institutions, mortgage lenders, would not lend money for people to buy these houses. So if you owned a house in this community and you needed to move, tough, you're not getting out of there. Mortgage lenders would not lend money for people to buy in this community because of the water and wastewater systems. Since they've gone in and fixed these, it has rejuvenated this community. You can now get money to buy and sell these houses. The moratorium has been lifted by Department of Natural Resources. New houses are being built. Before I move on, I'll just volunteer for you that Mr. Cox will be here on a multitude of issues. He's been to every one of these systems. He can talk backwards and forwards about every one of these systems. He knows about all these problems with the moratoriums. I invite you to ask him any questions you may have. He'll be up first thing tomorrow morning on the issue of consolidation. So how does Confluence Rivers effectuate its acquisition of troubled systems? Relevant to a later issue in this case, Confluence Rivers acquires the assets of troubled systems, but not the stock of the utility that sells the distressed system. The acquisition of assets versus the acquisition of stock of the troubled company is a critical distinction. In the event that Confluence Rivers acquired the stock of the company, it would then own the company. Part and parcel of that acquisition of stock, though, would be Confluence River assuming all the liabilities. So if the seller owed fines associated with environmental problems, we bought the stock, we would be taking on all the liability for those fines. If the previous seller had not been paying their employees, if we bought the stock, that would become our problem. But by buying assets, Confluence River is not assuming any of these liabilities. Once it has been assured that it has clean title to all the assets and can actually access the land, mains, and treatment facilities, only then will Confluence River close on the purchase of assets. But all the associated liabilities remain behind with the seller. So much as if you bought a used car, you would be buying the car. But if the previous owner hadn't been paying property taxes, that's on him, not on you. Buy the assets, not the company. Another key point is that Confluence River seeks to work out agreements called agreements on consent with the Department of Natural Resources. This agreement is an acknowledgement by the DNR that it will give Confluence River a reasonable period of time to resolve the problems in this system. The agreement is a reflection of the fact that no one would dare purchase this agreement if on day one they're subject to environmental liabilities. So we work out these AOCs with the Department of Natural Resources. Department of Natural Resources recognize that Confluence River needs this opportunity. Today, through this business model of buying assets, through the business model of working out AOCs to give time to renovate these systems, Confluence River and its predecessor companies have acquired roughly 70 Missouri water and wastewater systems through 36 acquisitions. Of those 70, 68 were in a state of noncompliance. 68 were part of the bigger picture I was just telling you about. One of the only instances in which it wasn't in a state of noncompliance was an elderly gentleman that perceived he was on death's bed and needed Confluence River to take this over so someone could operate it. There, Confluence Rivers represented his only chance of making sure service was continued to be provided. Some of these acquisitions were the result of hard work, out there hitting the pavement, talking to homeowners associations and other entities and seeing if they wanted out of the utility business. More typically, however, the work has come to us. More typically, Confluence River has been asked by state entities to fix these problems. For instance, of these acquisitions, the Department of Natural Resources purposely sought out Confluence Rivers repeatedly and asked it to acquire non-compliant systems. Today, Confluence River has acquired at least 9 companies and a multitude of systems at the request of DNR. In fact, based upon its past ability to come through for DNR, to take over its biggest problems, DNR submitted a letter for use in this docket, which lauded the efforts of Confluence River. It's a copy of that. That letter states in part, when systems are unable to resolve their technical, managerial, or financial problems, one reliable solution is selling the system to a higher performing utility operating company. In Missouri, Confluence River is one of the few utility operating companies who is willing to acquire some of the most difficult failing systems. Confluence River has consistently taken swift actions after taking control of these systems to bring them into compliance by employing qualified operators, effectively administering and managing the system, and investing in repairs and upgrades. Confluence River's willingness to acquire systems with long-standing compliance issue has proven to be beneficial to human health and the environment by bringing many of these systems into compliance with environmental laws. So why did DNR agree to submit such a letter on behalf of Confluence River? From what you could tell, it's just me telling you about it, but I can show you why they did it. Let's look at some of the pictures of a system that you heard about a lot down in Farmington, the Terre de Lac system, a system that DNR asked Confluence River to acquire. These pictures show several assets at that system with both the condition at the time it was purchased as well as a photo of Terre de Lac after Confluence River had finished restoring the life of the asset. Here's the Confluence River clarifier. I'll speak loud so they can pick it up, but here is a before shot. The clarifier, the weir. What's supposed to happen is it's supposed to kind of skim it off. That the sludge is supposed to maintain in here. The wastewater goes here, ultimately goes out for disinfection and discharge. But you can see here it's not working. Look at the amount of sludge. The amount of sludge that's going to be discharged out into the receiving waters. The aftershot. Look how it's cleaned up. Look how the water looks before and after. Another picture of the Confluence River problem is the oxidation ditch. The way an oxidation ditch works is there's a wheel here. This wheel spins. Wheel's throwing up water. It's aerating the water.
Mr. Woodsmall, we have a question from the commissioner. Commissioner, go ahead.
Thank you. Back to the Terre de Lac. What is the time frame from the time that you get it from the before photo to the after? How long does that take?
Depends on the asset. Mr. Cox can give you exact information. Many of these require DNR permitting. So you have to go through engineering plans. You have to get the DNR permitting. You have to do the construction. I don't know, a year, roughly a year. But I'll show you some pictures later of the things that we were able to do in the short term within 50 days to turn around the operations. And you'll see the effluent and the differences that not only we make in the short term, but in the long term. So
approximately a year
to get everything done.
Okay. Thank you. Thank you, Judge.
Here's the oxidation ditch. What happens here is wastewater moves around this ditch, but when it reaches here, this wheel's supposed to be turning, kicking this wastewater up in the air, aerating it. What you see, the wheel's dead in the water. It's not doing anything. There's no wastewater coming off of it. There's no aeration. Even if it wanted to, this sludge dam is keeping everything backed up. It's dead. Here's the after. Whoops. Here's the after. You could see it's throwing up the water. It's aerating. There's no sludge dam. The water's moving. It's being treated. It's being aerated before and after. Another part of the Terrelac system is the 3-cell lagoon. Here you can see the before. Here's one of the cells, all the vegetation, the duckweed on there. A mat of duckweed that thick is a problem. What it means is the air can't get down to the wastewater. It can't aerate it. There's no treatment. The vegetation, what you have here are muskrats digging into the berms, threatening the whole efficacy of the system. Here's the after. Duckweed's gone, aerator installed. The berms have been cleared out. The muskrats have been eliminated. Treatment's happening. Let's look at the water side. Terrelac drinking water tank. This thing hasn't been maintained for decades. Look at that thing. But worse, look at the inside. Look at this sludge and funk that's sitting there at the bottom of that tank. People are drinking that stuff. The after picture, painted, cleaned up, recoated. That's the Terrelac system. It's no wonder then why DNR is appreciative of the actions of Confluence River in acquiring and resolving their biggest violators. Further supporting DNR's assessment of Confluence River as a great actor in Missouri is that Confluence River is now the most tested water and wastewater utility in the state of Missouri. Most tested. We operate more systems in Missouri than even Missouri American. They're bigger. They have something like St. Louis County with hundreds of thousands of customers, but we own more. What that means is we're tested for every one of those systems. From the moment the water comes out of the ground at the well, we're tested. To the moment it comes down the discharge, out of the wastewater treatment facility and into the receiving waters, it's tested again. All told, Confluence River has submitted approximately 4,700 wastewater samples and almost 30,000 drinking water samples. A lot of samples, but you know what's more impressive? The almost perfection that's seen with these. In those approximately 35,000 water and wastewater samples, Confluence River has only had an exceedance 30 times. Out of 35,000 samples, only 30 times. The DNR letter applauding Confluence River is not an aberration, however. Here's a letter that was submitted on behalf of CSWR's affiliate in Mississippi, and this is important. The CSWR affiliate in Mississippi, Great River Utility Operating Company, operates under the exact same business model. It buys assets. It works out agreements on consent. It uses third-party operations. So based on that business model, what did the Department of Health in Mississippi say? As you may be aware, Great River has recently acquired several drinking water systems across the state. Great River Utility has worked closely with the Bureau, the Department of Health's compliance and field staff to maintain compliance with the various rules and regulations of the Safe Drinking Water Act. A viable entity such as Great River Utility desiring to help problematic drinking water systems by investing in them for improved services to utilities is very appreciated and supported by the Bureau. The Bureau appreciates Great River Utility's commitment to improved regulatory compliance, and the Bureau remains committed to our partnership with PSC to find sensible and feasible solutions to shared problems. This is a common theme across all the 13 states. We go in, we fix the problems for the relevant Department of Natural Resources, and they show appreciation. Requests to acquire troubled systems are not, however, limited to the Department of Natural Resources. Repeatedly, the Commission's staff has asked Confluence River to acquire some of their more troubled regulated systems. These systems were typically the subject of an AG compliance action or a court supervised receivership. When you have one in which the owner just walks away, you've seen it, you've been through it. You send your general counsel to the court and ask them to place that under receivership. And what happens? Those sat there for decades and decades. Confluence River comes in at staff's request and acquired these systems. We fixed the problems. In fact, of the 36 total acquisitions that Confluence River has made, 20 of these were Missouri regulated systems. And of those, the 20 problems that we took on, 19 were out of compliance. Clearly then, Confluence River has been the historical solution that staff has taken to assure that customers are provided safe and adequate service. So just as I showed you one for a DNR system that we were asked to take over, here's one that the staff asked Confluence River to take on. This is the Missouri Utilities water tank. This system was mired in a receivership for over 10 years. From these pictures, you can see why. Look at the outside of that thing. Look at the exposed wire. Look at just chemicals strewn about. Look at the rust, the afterpick. Rust sanded down, primed, painted. No exposed electrical. Let's look at the interior because it's worse. 4 inches of sludge and funk sitting in the bottom of that tank. 4 inches of rust being ingested because no one had bothered to clean that out. It's no wonder staff in the commission sought a receivership for that. But absent Confluence River, that stuff would still be there. Here's the interior of it now. Again, sludge removed. Rust has been sanded, primed, painted, pristine. As you can see then, given the improvements seen at this and other systems, staff once looked at Confluence River as the answer to its problems as well. That now seems to be changing. Based on its repeated willingness to take over troubled regulated systems at the urging of the staff, as well as the rate-making positions that staff has previously suggested in a multitude of previous staff-assisted rate cases, Confluence Rivers thought that Missouri was an environment in which it could continue to invest and acquire. Despite the presence of almost 3,000 troubled systems, the viability of further acquisitions by Confluence River or anybody else, based upon the positions taken in this case, must be questioned. So let's talk about some of the issues in this case. Let's talk about some of the issues that staff and public counsel have raised to place further acquisition into question. As an initial matter, I want you to think of one thing as you hear their positions. Think back to those local public hearings when you heard people griping about their rates increasing. And I'll tell you, they were griping because those rates had been in effect for 30 years. But I want to put this into perspective. Confluence CSWR is the parent entity. Confluence River is the Missouri entity, has no employees. Instead, CSWR does services for Confluence River, and those services are then, the cost of those services are then allocated. But think about this. To manage 850 systems in 13 states, CSWR does that with 70 employees. 70 employees managing the operations, the maintenance, the engineering, the legal, the finance, the billing for 850 systems. But let's make that more real for you. 70 employees, but in this case, staff and Confluence River agrees that roughly 8% of those costs should be allocated to Missouri. So what does that mean? 8% of 70 employees. That means 5.6 employees being allocated to Missouri. 5.6 employees running 68 systems in Missouri. That's cost containment. And in the year and a half I've been there, I can attest to that personally. That said, here are some of the issues that will likely cause potential purchasers to question future Missouri acquisitions. Let's start with public counsel. As I mentioned, public counsel has been a constant obstacle to Confluence Rivers for almost 10 years. Public counsel's opposition in this case was not unexpected. We know it was going to happen. They just can't see the light. I'm going to address OPC's largest issue. In its rebuttal testimony, Dr. Mark suggests that Missouri ratepayers have been harmed by Confluence River's utilization of third-party operators. Let's look at this. Dr. Mark's rebuttal testimony while lacking any experience in the water or wastewater industry. Any experience, let alone any operational experience, OPC took to simply drawing boxes on a map. By drawing boxes around the map of facilities, OPC definitively concludes that Confluence River could be run by 9 operators. Draw boxes on a map, count to 9, boom. That's their idea of staffing an internal operations team. OPC then suggests, based on a 2021 internet database, that each operator could be paid $48,000 in salary and benefits. After including taxes and other items, OPC suggests that these operators would cost a total of $540,000. OPC generously grants another $60,000 for overtime. So OPC says, based on boxes on a map, that an internal operation team would cost $600,000. Since Confluence River spends, though, $1.69 million for third-party operations, OPC recklessly levels the accusation that Confluence Rivers has been, quote, imprudent. Boxes on a map, imprudent. And recommends that the commission reduce the company's revenue requirement by over $1 million based on a kindergarten drawing boxes on a map. The silliness of OPC's conclusion is not only shown by the facts that it states in its testimony, but also by its ignorance of legal work safety requirements. Here you see a part of a table from Dr. Mark's page 11 of his rebuttal testimony. This is a breakdown of the responsibility of just 2 of the operators. While OPC suggests that operator number 6 would only be responsible for 2 current systems in Boone and Audrain County, it then concludes that operator number 3 should be responsible for 13 systems. I don't know about you, but I'd much rather be operator number 6 than operator number 3. That said, the area addressed by operator number 3 in the previous map is roughly 2,150 square miles. So let's work through the math here. Recognizing that operator number 3 is required to visually inspect each system 3 times a week, recognizing there's 13 systems, operator number 3 is expected to do 39 site visits in a 40-hour work week. At just an hour per site visit, and I'll tell you, I've been to these places, that's conservative. Operator number 3 would spend 39 hours a week doing site visits. But that doesn't account for any of the drive time in this 2,150 square mile box. That doesn't count for any maintenance. What if this guy goes out there and there's a spill, there's a blower out, there's something not working? Tough. I don't have time to get to that because OPC says I need to get over to this other system. Mixler Cox will tell you, however, that a site visit takes much longer than an hour. Still, again, by suggesting that operator number 3 can conduct 39 hours of inspection in a week, OPC effectively leaves 0 drive time for 2,150 square miles. Clearly, OPC's recommendation is not based in reality. As I mentioned, OPC's recommendation is also ignorant of legal work safety requirements. While it says that 1 operator can do 13 systems, it fails to account for OSHA requirements. OSHA requirements say that if you're dealing with a confined space, you have to have 2 people there, sometimes 3 people. If you're going down into a lift station, the guy going into the lift station must be there, an entry supervisor that's cleared it all must be there, and there has to be an attendant there. So while OPC says 1 person can do these systems, and most times it takes 2 or 3. Let's look at the OSHA fact sheet. As that fact sheet states, confined spaces can present conditions that are immediately dangerous to workers if such conditions are not properly identified, evaluated, tested, and controlled. This fact sheet highlights many of the confined space hazards associated with sewer systems, but it goes deeper. It tells you where these confined spaces are in a wastewater system. Sewer systems are extensive. and include many different components that are considered confined spaces, including pipelines, manholes, wet wells, dry well vaults, and lift pump stations. Therefore, employers conducting work in sewer systems will likely have workers who will encounter confined spaces. OPC says one person can do it. From this fact sheet, OSHA readily recognizes the prevalence of confined spaces in sewer systems. Sewer systems have a great deal of assets that are considered confined spaces. The important conclusion from all these OSHA regulations is that since wastewater systems rely extensively on confined spaces, many of the functions that OPC definitively concludes can be done by one operator requires 2 or 3 operators. Thus, simply by considering OSHA regulations that OPC ignored, it's not 9. Now we're all the way up to an 18-team internal operations team. Ultimately, given supervisory needs, however, and other requirements, including more experienced systems, Mr. Cox concludes that an internalized operations staff would require 22 operators. This number is not inflated. This isn't simply to make the analysis look good. After submitting this analysis in its SIR rebuttal, Public Counsel asked a data request to have us identify every operator that works on our system. Public Counsel, instead of asking this before they just blindly said 9 operators, Public Counsel, based upon our SIR rebuttal, says maybe we should do some work. Maybe we should delve into it. Maybe we should ask how many are currently doing it. In that data request, we told them last year 21 operators worked on our systems. OPC says 9. The deficiency of OPC's simplistic analysis goes well beyond this suggested number of operators, however. As mentioned, based upon a 2021 database, OPC suggests that this operator would only need a salary of $48,000. As Mr. Teese in his rebuttal states, however, OPC's compensation analysis is oversimplified. First, as staff even recognizes, that database is 2 years old. Need to reflect cost of living adjustments, and there's been inflation in the last 2 years. People aren't willing to work for the same amount of money as they did 2 years ago. Moreover, the Bureau of Labor Statistics states that taxes and benefits are 29.5% of an employee's compensation. Accounting for just these 2 changes, cost of living adjustments and taxes and benefits, that entry-level operator would need a salary of $78,000. Finally, OPC fails to account for the need that we now have to provide trucks and tools to this internalized labor team. Also, what about the cost for where we're going to store the chemicals? What about the excavators? What about the extra pumps and blowers and aerators and all those things? You think these internal operators are going to let us store that in their garages? We're going to need warehouses all over the state to hold all this equipment. It's not simply a matter of drawing boxes and multiplying by 48. All told, based on 22 operators, the total cost of an internal operations team, including just compensation, benefits, vehicles, and tools, is $2.2 million. Last page of Mr. T's SIR rebuttal testimony. Think about that, $2.2 million. We're getting third-party operations for $1.6 million. But OPC says we've been imprudent because it can draw boxes on a map. Let's move to staff's positions. As I mentioned, based upon staff's repeated urging that Confluence River acquire troubled systems at the urging of staff, as well as the rate-making positions it's taken in previous rate cases, Confluence River thought it had a roadmap that would allow for continued investment in Missouri. As I indicated, that conclusion must now be reconsidered. Undoubtedly, you've heard the phrase, quote, regulatory certainty. What is regulatory certainty? Regulatory certainty means that a utility or any other entity investing in this state needs to know the rules of the road. How are those costs going to be treated? Mr. DeSantis, in his return on equity testimony, will tell you Regulatory risk is one of the business risks that a utility must account for and be compensated for. In this case, the roadmap for acquisitions have changed, and staff has suddenly let the specter of regulatory uncertainty rear its ugly head. Now, relative to all the other states in which CSWR operates, the viability of further investment in Missouri is much less attractive. We've gone through rate cases in Texas, Louisiana, Mississippi, 2 of them in Kentucky. I don't even know if I've hit them all. We have never seen any of these positions of staff raised in those other cases. These issues that I'm going to tell you about, those are novel to Missouri, not presented in any other state, a complete 180 from what staff has done before. That's the definition of regulatory uncertainty. That is the definition of making Missouri less attractive than other states. At a time when Missourians are suffering from service from almost 3,000 non-compliant water and wastewater systems, staff has threatened the viability of their only solution, continuing to invest in Missouri. As part of the acquisition of the assets of the distressed water system, let's talk about preliminary engineering costs. But as part of its acquisition, we buy assets. We don't buy stock. So when we go in, obviously you're going to incur preliminary engineering costs. Such costs include an identification of assets, suggestion of necessary improvements, an analysis of condition of the assets, a determination of available capacity, some validation of the number of current customers, as well as the ability to add more connections. That's what preliminary engineering costs. Those reports are given to staff in every acquisition case. Staff finds them valuable, or else they wouldn't be asking for them. You know what happened here? Staff disallowed them. Other engineering costs are associated with the attempts to start mapping the assets. As Mr. Thomas will tell you, this is never a finished project, as we continually find manholes and lines buried under the brush in the woods. That said, it's important to get this started, not only for operational purposes, but to comply with state requirements. Missouri One Call, set up by the General Assembly, requires us to map this stuff. We get started mapping and staff disallows the cost. These are the type of preliminary costs that staff proposes to disallow. In his testimony, Mr. Majors just slaps the label of, quote, transaction cost on these preliminary engineering costs. By using that label, he suggests that the commission disallow it. Never delved into the cost. He just slapped a label on it and disallowed him himself. Mr. Majors claims, quote, transaction costs are costs incurred by the purchaser and seller to effectuate the financial, legal, and regulatory requirements of the merger. These costs are incurred prior to and immediately after the merger or transaction. Transaction costs are costs incurred by the purchaser and seller. These costs are incurred prior to and immediately after the merger or transaction. To support its position, staff relies upon a commission order back when KCP&L bought GMO. That talked about the commission's not going to allow transaction costs. But what's noticeable there, that wasn't KCP&L buying assets. That was KCP&L buying equity. The transaction costs were simply KCP&L hiring bankers, KCP&L contacting the New York Stock Exchange, KCP&L delisting Aquila. Nothing there of benefit to customers. I get excluding those there. That's not what's happening here. Buying assets. We're going out and making sure we have access to these systems. We're going out and making sure that the assets are there, whether they're functional, whether to begin mapping them for Missouri One Call purposes. These costs here that staff labels as transaction costs are all necessary for Confluence River to operate the system. Staff never inquired into these costs. Instead, as I mentioned, staff just blindly slapped a label on these costs and disallowed them. The part that's most amazing, however, is that staff disallows these costs, quote, if they're immediately if they're before or immediately after the merger. If they're before or immediately after the merger, staff disallows them. So staff said immediately after is 50 days. If you incur these costs within 50 days of the transaction, we're going to disallow them. What's the perverse incentive created there? The perverse incentive is while we can go in and make fixes and turn things around, don't do it. Wait 51 days and then staff will allow them. Sit on your butts, twiddle your thumbs, do nothing because you're going to lose those costs. Wait 51 days and we'll allow them. Confluence Rivers thinks this is bad policy, and once upon a time, staff did too. As Mr. Teese points out, staff has previously allowed such costs in case numbers WR 2020-0275, WR 2020-0053, WR 2016-0064, SR 2016-0202, and WR 2017-0259. Staff has allowed these costs. Regulatory uncertainty, do a 180, disallow them. As I mentioned, Confluence Rivers thought it had, based upon positions previously advanced by staff, a roadmap for the acquisition of systems and the recovery of cost. In this case, the staff has introduced a great deal of regulatory uncertainty and changed that roadmap. CSWR entities have pursued rate cases in Kentucky, Louisiana, Mississippi, and Texas. In fact, 2 Kentucky rate cases. Never before this case has someone tried to disallow these necessary costs for the operation of a utility's assets. As I said, staff's position, if adopted by the commission here, introduces a great deal of concern regarding the viability of future acquisitions in Missouri by anybody. Will anybody come into Missouri and buy assets if they're not going to get the recovery of the engineering cost? When faced with 3,000 non-compliant Missouri water and wastewater systems, staff should be looking at positions that advance the acquisition of these systems. Instead, they changed their mind and hindered that goal. That's called not seeing the big picture. But what kind of improvements, given what Commissioner Holzman said, what kind of improvements can be done in the short term? Here are 2 pictures. I'm sorry it didn't blow up well. Tear-to-lack system. In 50 days, these are the type of improvements that can be done. In 50 days, however, these costs would be disallowed by staff. Before, look at that sludge. Look at that water discharging. In 50 days, sludge is gone. It's treated. Look how clean that is. There's no sludge blanket down here. Staff disallows all the preliminary engineering costs to make that happen. We should have waited 51 days. Let the customers suffer with that because then we could have gotten these costs recovered. The costs go beyond simply preliminary engineering costs. They go to preliminary legal costs. Again, staff slaps a label of transaction costs on these costs and claims that the commission should disallow them. Again, staff fails to dig deeper. Staff fails to see that these aren't transaction costs. What are these? These are costs related to getting clean title to the assets, to make sure that it wasn't bought with a loan and that the liens have been released on these assets. These are systems to acquire an easement so we can get to the assets. Fox Run, when we bought it, there was no way, no legal way to even access that system. There was no legal easement. It was out in the middle of nowhere. The previous owner was just walking in, but we couldn't get access to it. How are we going to get in trucks and other equipment to replace those assets? So we incur preliminary legal costs to get an easement. We do preliminary legal costs so we get clean title. We incur preliminary legal costs, so whereas in Margaritaville, we assume a wholesale water agreement to make sure we can get water to these systems. But if these preliminary legal costs are incurred within 50 days, staff disallows them. Again, we should just wait 51 days so we can incur these costs. These are necessary for the operation of the system. These aren't incurred so you can delist the seller's stock on the New York Stock Exchange. Again, this is bad policy and will inevitably make the acquisition of future systems in Missouri much less attractive than other states. Let's talk about another issue, net operating loss. Again, a complete 180 by staff. Tough issue to understand. You really have to dig in on this. Every time I hear taxes, my eyes glaze over. The Internal Revenue Code allows a business to book a net operating loss and carry them into the future to use as a deduction against taxes at that time. Think about the Confluence River business plan. We buy bad systems that have not had rate increases for a long time. These systems are missing blowers and pumps. These systems are missing disinfectant systems. So what happens? We go in and we buy a system. But in the case of Port Perry, those rates have been in effect for 30 years. Those rates don't reflect cost of service, let alone the cost of service once we begin operating. Because we go in, first 50 days, we're replacing that blower that's missing or burned out. We're replacing the pumps in that lift station. We're putting in the dechlorination. So what comes with that? You put in a blower that wasn't there, electric costs go up. You put in a dechlorinator that wasn't there, chemical costs go up. Rates are way down here, not even covering the costs at that time. We go and do other stuff, operating costs go up. What you have there, a net operating loss. Additionally, upon acquisition, Confluence River will begin immediately inspecting these systems 3 times a week, another cost that goes up. So combining the depressed date of the rates with the increased costs, you have net operating losses. Important to this distinction, however, is the difference between regulatory books and tax books. Under flow-through rate making, the parties include the level of taxes that result from the earnings generated from current rates. You're not looking at the amount of taxes that are paid at that time. You're looking at what the rates would generate, and you include that level of taxes. Because the net operating losses won't be realized, won't be put to use till sometime in the future. So after current customers have received the benefit of deflated adopted rates, have received the benefit of increased operating costs, staff then wants to say those current customers should also get the net operating losses. We're not going to include any taxes in this case. We're going to use those net operating losses for the benefit of current customers. But we haven't even been able to use those yet. So staff, the implications of this, if we use them in the future, when at 5 years down the road, we would then take those net operating losses and reduce rates at that point in time. So staff is robbing future customers of the net operating losses to benefit current customers that have already seen the benefit of the adopted rates. The other problem with it, staff will say, they'll attempt to frame this issue. They will tell you, company's not paying any taxes now, so they shouldn't get any taxes and rates. Staff will tell you that this is, quote, a phantom tax. As you well know, however, there is nothing phantom about taxes. As Benjamin Franklin understood about 250 years ago, there are 2 certainties in life, death and taxes. So the practical effect of staff's proposal is to rob future customers from the benefit of this net operating loss when we use it to benefit current customers so that they don't pay any income taxes and current rates. The other problem is, the other entity that is upset by staff's position is Confluence Rivers. Investors are investing in Missouri with the understanding that they have to temporarily cover net operating losses for the customers. These were the rules of the road as set out by staff in every previous rate cases. Staff never attempted to use these net operating losses to shield customers from income taxes. Investors thought that they would only have to cover these net operating losses until the first rate case. After that, rates for these customers would be fully compensatory, including income taxes. Investors would no longer have to cover losses for these customers. We've covered the losses all the way up till now. It's time to get them on a cost-based rate, including income taxes. Now staff has changed the rules of the road. Staff is saying, we know we didn't use those net operating losses in the past. We know we're going to let you save those for the benefit of future customers. We know you will now get those revenues and start having to cover their operating losses. Staff now says, whoa, pump the brakes. We're going to use those net operating losses. We're going to take those revenues out of your pocket. We're going to take those benefits away from future customers. The other thing is radical deviation from staff's position previously, but it's also directly contrary to the position of other states. Again, 2 Kentucky rate cases, a Mississippi rate case, a Louisiana rate case, and a Texas rate case. No one else has proposed this. Let's move on to another issue. This is the system repair expense versus capitalized life restoration cost issue. Staff took numerous issues that the company had capitalized as a life restoration cost and instead just called it a maintenance expense. Capitalization versus maintenance, that's what this issue is about. The reclassification of this cost as an expense was made worse then by the fact that staff then normalized it over 3 years. As such, the practical effect was for costs that Confluence River had capitalized, it would now lose recovery of 2/3 of the cost. Once again, staff seeks to blindly place labels on costs without ever digging into the realities of the cost. Staff just looked at things and said repair, but never went and looked at the system to see, was that just a repair? For instance, staff seeks to classify such costs as a repair expense by analogizing to a tank painting. Confluence River doesn't dispute if these are fully functioning assets like a water tower, then the tank painting would be a repair expense. But what if this thing hasn't been painted in 20 years? What if this thing is rusted and leaking? What if it's flaking rust into the drinking water? What if this thing has effectively no service life left because of the lack of previous maintenance? Is that a repair? Rather, the costs incurred are necessary to restore the life of the asset. So, for example, consider a wastewater tank that has been neglected and is completely impacted by sludge. Wastewater comes through and it runs through tanks at which aeration and different things happen. But what if it's been ignored and that thing is now completely full of sludge? What's going to happen? Wastewater is going to come in, it's going to skim across that bank of sludge, go into the next tank, out into the discharge. No treatment happens there. Those tanks have no useful life. So if we go in and remove the sludge, is that maintaining the asset? Is that a repair? That's a life restoration. We have restored the life of that tank. The useful life of that tank with the impacted sludge is 0. We're restoring, not maintaining the life of the asset. This is not a repair expense. This is life restoration that should be capitalized, not expense. So let's look at 2 systems where this happened. Cedar Green at the lake. Multiple tanks. Wastewater comes across, so as to get treated, moves on, treated, moves on, treated. What do you see there? Impacted by sludge. There's no treatment going on there. That wastewater is immediately going out. Afterwards, cleaned it out. Look at that water. No sludge. The water is going into tanks and it's being treated. It's not being discharged without any treatment. Life restoration, that's not a repair. Let's look at another one. Chelsea Rose at the lake. Impacted with sludge. No treatment going on there. Here it's been cleaned out. Treatment going on. Not maintenance expense, not a repair. That's life restoration. Those assets had 0 useful life when we bought them. The staff wants to say we're maintaining them. We're maintaining them at what? 0 useful life? Life restoration. As such, Confluence River's position is that these costs should be capitalized. Also reflects the dictates of the Internal Revenue Code. Now, I'll tell you, the Internal Revenue Code is not binding on you. That's taxes. Not claiming it's binding on you. What I'm claiming is the Internal Revenue Code can provide you some guidance for determining what is a maintenance expense, what is a repair expense, and what should be capitalized. The Internal Revenue Code provisions state that if these costs are made, quote, for a betterment to a unit of property, end quote, and if these costs, quote, ameliorate a material condition or defect that existed prior to acquisition, end quote, the Internal Revenue Code demands that these costs be capitalized. Confluence Rivers believes that that is sound guidance. If we are bettering it, if we're returning the life because of bad previous neglect, that should be capitalized. It's not a repair. The Internal Revenue Code says so. We believe it's good guidance for rate making. As such, if adopted by the commission, staff's position would significantly reduce the viability of future acquisitions in Missouri. So let's get to the bottom line. This is as of the reconciliation that was filed earlier this week. Our rate case increase at this point in time is roughly $2.5 million. Staff's recommended increase is $931,000. Despite all the improvements, all the systems we bought, all the lives we turned around, Public Counsel says we should get a rate decrease, largely driven by the fact that they want to disallow $1 million of operations costs. But again, reflecting their inability to see the bigger picture, reflecting their inability to see what is the impact of this, this won't allow us to cover our debt cost. Last December, you'll recall, we asked for permission to issue debt, and the commission gave it to us. We issued $7 million of debt. But given the fact that we were operating under current rates that didn't produce any income, the lender said, I'll tell you what, you have a rate case going. We won't make you cover those interest costs till December when your rate case is done. So what's going to happen? We need to have the free cash flow to service that debt. We need to be able to pay that interest come December. Staff and Public Counsel's position won't allow that to happen. We won't have enough cash to cover our debt costs. So then what happens? The lender is going to come in and say, I want that money now. You're not covering your debt costs. You've defaulted on your debt covenants. We want that money. What's going to happen? We've defaulted. What's that mean? We'll never get another credit. We'll never get a credit rating. We'll never get debt in Missouri again. And we'll be stuck with 100% equity capital structure because staff and Public Counsel don't want us to cover our debt cost. Because staff and Public Counsel said, yeah, go ahead. We recommend you get that debt, but then we're not going to give you the rates to cover those costs. That's the big picture. That's what staff and Public Counsel refuse to look at. I've finished talking about the financial issues in this case, but I want to be cognizant of one other thing. Throughout this case, I want you to be aware of many of the other recommendations in this case and how they will affect Missouri utility costs. While it does not include the costs in this case, staff wants the commission to order Confluence River to hire a full-time employee simply to coordinate with third-party operators and to assist staff when it conducts its inspections. This will be a cost in future rate cases. Confluence River currently does it with a shared employee with Tennessee. Staff wants one all of their own. With staff at these local public hearings where people were griping about rate increases, what do you think their recommendation does? It ups costs and puts pressure on rates further. Staff wants us to do a bunch of reports solely for Missouri. Information that's otherwise available to staff. Staff comes in and does an audit, says, give me the invoices for every electric bill. We give it to them. What staff do? That's not easy enough for us. They use the word convenience. We want these reports for our convenience. We want you to keep a report. We want you to hire somebody to keep a report so that we can just go into a rate case and say, give us the report of your electric cost. What's that do? We have to hire somebody to do that. Rates going up. But the other part of that is, should they take our word for it? If we give them a report, are they just going to take our word for it? They're not. We'll give them the report and then they'll say, give us the invoices to support it. So why do the work to do the report in the first place? All it does is create a need for further work in Missouri. That 5.6 employees that I told you are currently operating in Missouri, we add another one for their state alone inspector. We had people to do these reports that will largely be worthless. You know, rates going up. Public counsel takes it one step further. Public counsel wants us to do customer surveys. Public counsel says, you know, we got Missouri American to agree to spend $100,000 for a customer service third party to come in and analyze things. Missouri American agreed to $100,000. Don't you think you should put that in perspective? If you scale that down for the size of Confluence River, if you account for Missouri American is so much larger, has so many more revenues, so many more customers, you know what that 100,000 becomes? $1,200. But public counsel wants us to spend $100,000. There goes rates. Staff and public counsel spend like sailors on leave. It's easy to spend other people's money. We believe that we should be allowed to continue to contain cost. The last thing I want to talk about, now that I'm done with the financial issues, and based upon some comments in a recent agenda session, it is clear that the commission has some concerns about service quality and customer service issues experienced in the testimony at the local public hearings. Let me be very clear. Been at this company for 16 months. I've seen the battles. I see the conversations. I see the meetings. Confluence Rivers takes these concerns very, very seriously. It didn't simply just go down to these meetings to let people have an opportunity to air their concerns and then drive off and go back home. We logged all these concerns. Along with staff, we provided an analysis of what we learned from hearing those concerns. We looked at our customer service database. We looked at our operational database and see, well, this one guy said we didn't mow around the berms. Did we mow around the berms? Let's go back and check. You know what happened? It had rained for weeks before that. You couldn't mow. We told the guy, take a break. When it stops raining and it's dry, then mow. Those are the things we learned. We took those issues seriously. We didn't ignore them, I promise you. Every Monday morning, we have a meeting. All senior leadership is in this meeting. It lasts a little over an hour, and we talk about all the issues that have come up in the past week. We talk about operating things. We talk about getting permits. We talk about our rate cases. We talk about everything. You know what takes the longest amount of time? The discussion about customer service. By far the biggest issue. At that meeting, we talk about issues such as average hold time, length of calls, percent of dropped calls, staffing levels at the third-party call center, and other important metrics. We look at this weekly. We look at trends. Are drop calls going up for some reason? Is average hold time going up? What can we do to effectuate improvement? One of the things we did to effectuate improvement is we hired a third-party, well-established customer service expert called McIntosh and Associates. The final report from McIntosh was only completed in the last couple weeks. That's why it didn't make it into testimony. While we commissioned it way back at the beginning of the year, we just got the final report. McIntosh came in. They talked to numerous employees. They worked over at our call center for days and watched how they handled things. They listened in on calls, and they made suggestions. And already CSWR is taking steps to implement those recommendations. Mr. Cox and Mr. Thomas will be happy to answer your questions regarding the steps that CSWR has made to make improvements. For instance, it's my understanding that today, CSWR is now finishing every call to the call center with a simple inquiry. 3 questions. Did they answer the call on time? Did you have to wait? Those type of things. Were you satisfied? And did it resolve your call? Every call to the call center now gives the opportunity for that type of inquiry. That's what we learned from this. We're listening to the customers. We're trying to improve customer service. We're not just ignoring it. Another step Mr. Cox discusses is the recent creation of a corporate communications department. Among other things, that department will be responsible for highlighting the improvements made at individual systems. You'll recall several individuals showing up at the local public hearings and being asked, have you seen any improvements? Routinely, they would say, no, I haven't seen anything. But think about it. Think your own service. If you got asked that, would you know what kind of improvements are being made? Would you know if a pump has been replaced? If suddenly we're now meeting all limitations? That stuff happens behind the curtain. I know I'm completely oblivious to it, but it doesn't have to be that way. You know, while they can't see it driving down the road, we can do things to make that more apparent to people. So we've created the corporate communications department. This will allow on a state and system basis to tell customers, these are the improvements we're making. Rest assured that we're just not continuing to do what the previous owner did. We're making these improvements. So we're trying to be more transparent to the customers. Another thing, CSWR has recently revamped its webpage to make the site more user-friendly, not only to find necessary information like those improvements, but also for ease in paying bills and making inquiries. Here's a copy of our new webpage. Finally, consistent with staff recommendations, Confluence River has agreed to continue to provide monthly customer service metrics. I told you we meet weekly to discuss these things. We are going to continue to provide them on a quarterly basis to staff. We want to be transparent. Moreover, Confluence Rivers has agreed, based upon a recommendation of staff, to have quarterly meetings with staff. Willing to have those meetings to discuss these metrics, changes being made to customer service like the Macintosh report or staffing at the third-party customer service entity, and we'll listen to staff suggestions and concerns. All of this should demonstrate CSWR's commitment to customer service. While Confluence Rivers has taken numerous steps towards improving customer service and is willing to listen to the input of other parties, what Confluence Rivers will continue to resist is Public Counsel's continued efforts to worm itself into the company, to insert itself into the operations of the company, to feel like it is more capable of operating the company because it can draw boxes on a map. Not only does Public Counsel not have the practical experience to produce those benefits, its constant efforts are frankly disruptive. So we will talk with people, but we're not going to let them have calls on what third-party entity we hire for doing what. Those are operational functions, and as the chairman mentioned in agenda session, we don't go there. We let them operate the company, and you can come in and criticize later. But while we take customer service very seriously, I believe that you also need to see the bigger picture. Try to place these local public hearing comments into some perspective. We're taking them seriously, I assure you, but they need to be taken into perspective. Such comments were made in the context of a rate case where a lot of people were getting large rate increases. You may recall if you were at Farmington, all the Port Perry people that were dressed in red t-shirts, do you remember them? Whole slew of them. Why were they there? Port Perry, a regulated system, has not had a rate increase since 1993. I worked that case, my first case out of law school. They haven't had a rate increase for 30 years. Do you think those people are upset when we buy them and finally they need to see a rate increase? Of course they're upset. You know, and it's not surprise. We knew that was going to happen. We knew they were upset, and we knew they needed the opportunity to tell us they were upset. We took it serious, but you should also know those concerns were raised in the context of a large rate increase that they haven't seen in 30 years. To put this in perspective, Confluence Rivers believes the context of these customer service, you need to realize the context in which these were made. Mr. Cox went through and we did a very thorough analysis. Confluence River has 9,684 water and sewer connections. 9,684. Of all those connections, 263 either submitted comments or submitted testimony at a local public hearing, 263 of 9684. We went back and looked at the name for all 263. We wanted to see, have they complained to us? Have we dropped the ball somewhere along the way? Did they tell us about a problem that we just missed? So we went through all 263. Of those, 40 only 40 had ever contacted us. Suddenly, we do a big rate increase, and while those concerns may be legitimate, they'd never called us before. But suddenly, in the context of a rate increase, yeah, those concerns become a little more intensified. So that's the context. 40 of the 263 had ever contacted us before. Further demonstrating the relevance of the rate case environment, of the 263 that had submitted comments or testimony, 233 of those were going through their first rate case. So people like Hillsborough and Indian Hills that have already experienced rate cases, they weren't complaining. These were all people going through their first rate case. These are all people like Port Perry that hadn't seen a rate increase in 30 years. So those are the people that were complaining. If we had systemic operations or customer service problems, if they were truly systemic, those concerns would be reflected not only amongst people getting their new first rate increase, it would be everybody. And we didn't see that. The people that were concerned were the people getting their first rate increase. And I don't want to minimize their concerns. We took them seriously, but we also need to put that in perspective. The big rate increases in this case are intensifying any concerns they may have had. In the ultimate analysis, however, the beauty of the water and wastewater industry is in the fact that safe and adequate service can be measured by purely objective metrics. As I mentioned, Confluence Rivers now submits more water and wastewater samples than any other entity in Missouri. Moreover, as I told you, we test the water when it comes out of the well all the way to when it's discharged into the stream. So Confluence Rivers has now submitted almost 35,000 samples. In all those samples, Confluence River has just failed 30 of 35,000. Moreover, Confluence River has never missed a milestone under one of its agreements on consent with DNR. While that's not perfect, it's damn close. Missouri is the show me state, and we've intended to show you, and we believe we have. So bottom line, as I mentioned, Confluence Rivers is always willing to make improvements, not only to operational matters, you saw the pictures, but also to customer service. I would encourage you to attempt to place the comments, however, into perspective. These are not systemic, pervasive problems. At the end of the day, I ask you to take away one thing again. Keep your eye on the bigger picture. Don't decide these issues in a vacuum. Decide them on, well, will this discourage anybody else from acquiring systems in Missouri? Will this discourage fixing up systems? Will this just simply maintain the status quo? Will this cause Confluence River to miss its debt covenants? Don't take issues in a vacuum. Consider them in an overall bigger picture. I know it's been hard for you. Thank you for your patience and attention. I'm available for any of your questions.
Thank you, Mr. Woodsmall, for your statement. We do have a commissioner question. Go ahead, Commissioner Hahn.
Thank you so much for the presentation.
you.
Really helpful. I do have a couple of questions about the customer service components that you'd mentioned. First, I just want to applaud you on taking this into consideration. About some of the items that you'd mentioned implementing, specifically the corporate communications department, when did you implement that new department? How many staff do you have roughly working there?
What is it, March timeframe? Okay, over a year. We have 2 employees completely dedicated to that and a manager that handles that and some other duties. So let's call it 2.5 employees.
Great, thank you. Also, when did you revamp the webpage where people could actually contact someone from CSWR?
About the same length of time. beginning of this year? It's a good point. There was always information on the webpage. There was always information to tell them how to contact us. What we realized, though, was it wasn't user-friendly. Finding those places was not obvious. So while they could contact us, honestly, we made it difficult for them. So we looked at that. We had a company called Ansira look at it and say, you can improve this. So about a year ago was when we revamped the webpage.
That's really helpful. Thank you. And then, when did you institute the the call center post question follow-up?
That would have been the beginning of this year as well. That's when we commissioned it, when we got the scope of work, and when shortly after that, they began meetings not only with internal people, our internal customer service people, but also listening in at the third-party call center, monitoring those calls. Yeah, while they started earlier this year, the final report just came out the end of July.
So perhaps some of the public comments could have been people trying to contact the company prior to these reforms being made.
Could have been. What we see, though, and this is reflected in Mr. Cox's rebuttal testimony, we monitor the number of calls. We monitor how long it takes to be answered, and we monitor the number of drop calls. So if people contacted us, we're able to provide statistics on that. The industry average for drop calls is 7%. We're running under 1%. So I don't see any drop calls or any customer service issues being the result of people calling and getting lost in the system.
Thank you.
You're welcome.
Thank you. We also have a question from the chairman, and I would like to take a second. We've been having the first opening statement go on. For the record, we do have the attendance of Commissioner Maida Coleman, as previously announced, and Chairman Roop. Go ahead, Chairman.
Great, thank you. Just to follow up on Commissioner Hahn's question, or line of question about the customer service. Actually, it's not a question, it's a statement. I have experienced local public hearings for large utility companies that have had people come forth and have complaints about customer service because they had complained at other public hearings and nobody listened. The company, like you said, went back and did all its due diligence and like, what happened? What happened? And what they found out was that the electric utility had actually fixed all the problems 2 years prior. But the mindset of the company was an engineering company. And they're like, hey, cool, we fixed it. Woohoo. Nobody told the customer. So the transition of utilities over the last decades is you're not a utility company anymore. You are a customer service company. And if you're not communicating that to the customer, they will never know. I mean, how would they know that they were what you've done behind it? So it is in your best interest to communicate, with those customers. Hey, this is what we did. No one else is going to toot your horn for you. And if you don't let them know the investments you're making and that you fix these things, because you're not competing on a customer service stance against other utilities. Your competition is the restaurant that customer ate at the night before and the great customer service they got, or whatever company they just interacted with. It has nothing to do with it. Your competition for customer service is the restaurant, it's the online ordering, it's the retail store that they just experienced. They expect you to have that same level. That is your competition on customer service.
I appreciate your comments. One of the things I just popped into my head, you're talking about closing the loop with the customer, not fixing it and just, leaving it hanging. One of my pet peeves, I just experienced this week, had to call in to get a refill for a prescription, called the doctor. I go to the pharmacy, it hadn't come in yet. I went to the pharmacy the next day, it hadn't come in. I changed doctors and they told me when it was at the pharmacy, they closed the loop. I was a happy camper. So closing the loop is critical. I agree with you. Hopefully with our corporate communications department, we will do better about that. But your comments have been heard.
We have two more questions. First, Commissioner Holzman and then Commissioner Coleman. Go ahead.
Thank you. So my question is going to be from that big picture macro perspective, and I don't necessarily anticipate you'll have an answer right now, but I think as this hearing unfolds, maybe we can get to it. One of the things that we consistently heard during the public hearings was from individuals who said, my system has not been improved, but I'm going to receive this percentage of an increase. And we know that there's going to be some socialization that goes on when a company who operates 68 systems is going to spread that cost out. If you take Terra Dulac, the amount of improvements that it looks like you've done on that one system, you know, you gave 4 pages of before and after photos, is probably going to exceed, you know, the amount that the customers in that particular system is going to be able to afford a direct one-to-one investment increase to pay that back. So that is going to have to be spread out amongst the rate base. But what is your company's response to that individual at that public hearing who says, that's great that you fixed Terra Dulac, but how are you taking the 2.4 million that you're asking for and determining, is it just a blanket all 68 systems, or can you micro produce the investment that you're making and share the expense when a system is improved, that those rate customers are going to have a more lion's share of that increase as opposed to a complete 100% socialization across all of your rate base?
Okay, so several factors in play here. The improvements at Terra Dulac, certainly apparent to you because you've seen the pictures. Those are replicated at numerous systems. Port Perry, you'll see in Josiah Cox's testimony, pictures of where we hauled huge trees out of the lagoon. So customers are oblivious to that. They don't need to be. We need to do better there. But what I'm saying is, while they don't know it, improvements are being made everywhere. Beyond that,
Will you have any customers who have a rate increase that did not receive any investment?
no. They will receive initial investment at a minimum. At a minimum, when we go in there based upon our preliminary engineering cost, we will replace gone or blown out pumps and aerators and blowers. So there will be investment like that. In addition to that, there will be long-term investment. So while some of the improvements you saw at Terra Dulac were both in the short term, you saw what we did in 50 days, there are also long-term investments. So there will be, I won't deny it, there will be systems like Glen Meadows. Glen Meadows was just bought in December. Will they see all the investment as Terra Dulac? Of course not. But they will see that initial improvement from what we call triage work. The long term, however, we can't take care of that right away. We have to submit for permits from DNR. If we make changes to the operational process there, if we change a hydropneumatic tank, storage tank, to a full ground storage tank, we have to get permitted by DNR. Then we have to get the equipment. So long-term is not something that we want. It's something imposed on us by permitting, construction requirements, availability of engineers. So to get to your question, everybody in this case, I would venture without fail, has received at least that preliminary investment, the replacement of blowers and that type of thing. They will receive the immediate operational from professional operators. The long-term investment, some haven't seen those. Getting to your socialization, while some haven't seen them, everybody will see them. Over the course of a decade, everybody's going to see this. It's a constant rolling ball. While you haven't seen it on your system, you'll see it next year. And then someone else is going to see it 3 years. And then 10 years after that, the system back here is going to need something. That's the point of consolidation. It's fair. At some point, everybody is going to need this. And the commission has recognized that in repeated Missouri American cases. Initially, staff wanted 8 separate districts, and the commission is now down to 2. The commission has said, this is fair. Everybody's going to need this investment. Why wait until someone has it? And if you don't consolidate, when that ABC system finally needs it and they have 12 customers, their rate's going to go through the roof. It's going to be like this, and then it's going to be the spike. So being able to socialize, being able to spread those costs over a larger number of customers like Missouri American, that's what helps mitigate the rate increases in this case. Do we know what some systems will get as a result of this case if you don't consolidate? Heck yes. Some of these systems are going to see 300 and 400% increases. Thus the need for consolidation. So everybody is seeing investment. Everybody eventually will see the long-term investment. It will replicate itself, and consolidation is necessary to mitigate the rate shock that comes from those long-term investments when they happen.
So what kind of efforts is the new corporate media team doing to address that part? Because we heard it at almost every public hearing. I don't want to pay for someone who's, miles away from me that we didn't get. Is that message being delivered to the customers today?
So at the beginning of this case, we have to, consistent with commission rules, send notices to all the customers. We tell them our position on consolidation and what their individual rate increases will be. And we tell them in that we are proposing consolidation. I don't have the notice in front of me, so I can't give it to you word for word, but there is talk in that customer notice at the beginning of the case of what we are proposing. In addition, in advance of the local public hearings, we sent another customer notice. And at that, there was further information given. What is planned for corporate communications at the end of this case, I don't know, but I certainly believe I have heard your concern. We'll take about it. We'll take it back and we will meet on it on Monday and we will discuss this. And I see the value in that. I see the value of closing the loop and telling these customers. So yeah, message taken.
So this $2.4 million that you're requesting, does that get you caught up for all of the systems that you've repaired to date?
No.
No.
It gets us caught up. In every commission rate case, the commission uses historical test years. Okay. So in this case, the test year has gone through January 31 of 2023. So all the systems that were in existence as of that date are in this rate case. We've acquired, I don't know, a half a dozen since then. They will not be subject to this rate case. They will continue to be charged under their adopted rates. When we get to, and this is what I was telling you about, when we get to the next rate increase, I hate to say it, those customers that have been acquired that are under adopted rates, those are going to be the ones that we hear loudest from in the next rate increase. Those are going to be the ones that now see their rate go up. What you're going to see, though, for the ones in this rate case is hopefully because of economies of scale, some of their rates will go down. And we're seeing it in this case. Hillsborough, Indian Hills, Elm Hills, those systems have gone through a rate increase. Because of consolidation and the economies of scale, they're actually seeing rate reductions. Hopefully, when we get to the next rate increase, those that scream loudest here, Terrelac and Port Perry, will see the rate reductions. It's always a cycle. Go up, taper off. Now this group, go up, taper off. And so the systems we've bought since January 31st will continue under adopted rates until the next rate increase.
You mentioned that you had $7 million in debt that we granted, and if you don't receive this increase, that you will be potentially defaulting on that debt. If you do have the rate increase adopted, how long is that $7 million going to be? How long will it take to pay that off?
Mr. T, 7 years. Thank you. 20 years, I'm sorry.
20 years.
Okay. It will be paid off in 20 years. Let me tell you what's magical about that. That level of debt does not only reflect current operations. As I've told you, we continue to buy systems. We continue to, once we buy that system that aren't in this rate case, Once we buy that system, we put them under adopted rates. So there's, for those new systems, net operating losses. We have net operating losses. Those net operating losses from new systems put pressure on that debt, the ability to service debt. If we're losing money here, we don't have that money to service debt. So if you try to cut it too close, I don't know what the magic number is. Let's say it's $500,000 of free cash flow to service current debt. If you try and park it right on that number, we can't acquire anything else because those net operating losses eat into that. We need some level of buffer to account for the fact that we have losses from X system, Y system, Z system. So don't park it too close to what we're going to have to pay for debt costs in December.
All right, it's my last question. You mentioned that you have 9,900 and some customers, just under 10,000, and you're continuing to acquire systems as we go. What is the company's 5-year plan for how many customers it is envisioning acquiring over that period of time?
I will tell you, please talk to Mr. Cox about that. He's up first thing tomorrow. He has ideas. Everything is subject to a great deal of change. I don't want to make threats, but what comes out of this rate case, the policy positions here will affect whether capital comes here or goes elsewhere. The systems that become available. Does a homeowners association start getting DNR letters and they now want to sell? So it is impossible to say with any type of certainty, these are the systems that we will acquire over the next 5 years. I believe Mr. Cox probably has some projections that if things go well on the decisions in this case, if things come out of this case that allow us to invest, I'm sure has projections that here we're at 9,600. This is where we want to be in 2 years and in 5 years. I think he can probably give you those. But as I'm saying, not subject to a great deal of assurance.
Thank you. Thank you, Judge.
Thank you. And Commissioner Coleman.
Thank you, Judge. Mr. Woodsmall, during your opening statements, you talked about the red shirts that was there in the audience during the local public hearing. And I remember those people, and there was a great turnout, and that was a very, very, very long hearing that day.
And we intentionally proposed a local public hearing in that area. We knew what we were running into. We knew these people hadn't had rate increases and they would show up, but there needed to be a local public hearing
Sure.
there.
And that's leading toward actually my comment that as a commissioner, we commissioners like to see what the community that's being served thinks and feels. You talked about the 200 plus comments that has come in regarding this case, and of those 200 plus, there's only been 40 that you've traced to having reached out to your company before regarding issues. My question regarding that is, would you tell me just a little bit more about your call center? Does the calls that come in, are they going to a call center that specifically deals with Missouri-based customers, or the whole portfolio of Confluence?
It is a third-party call center that my understanding is completely dedicated to CSWR.
Okay.
So they're not dealing with a Target store. It is a third party devoted solely to CSWR, but they do handle calls for all 12 states in which we currently operate.
Okay.
Beyond that, I will tell you the customer has early on the ability to request a live agent or to proceed through an IVR, interactive voice protocol, the thing where please press 1. So it is for all systems, and they can proceed in a number of different manners.
And do you have the information, or will someone else have it, regarding how many calls in general from all of your customer base you get? How do you get the information regarding where these calls are coming from?
The third-party entity, Nitor, gives us every week for the previous week a number of metrics. They will tell us you had 1,000 calls. I don't know. First off, let me tell you, Mr. Thomas oversees customer service, and he can answer this with more specificity. That said, to get to your question, they will give us metrics that say, of the calls, X% are related to Confluence, X% are Mississippi, and they will give us hard numbers. And we will see that vary on things. If the tornado hits Kentucky, as happened in Mayfield, yeah, calls are going to go up there. So we're able to watch that on a weekly basis, look at trends, try to look at, well, what caused this spike? Was it Winter Storm Uri down in Texas when everything was freezing up? Is it the fact that, wow, it's been 2 weeks since we gave a notice of a rate increase? Maybe that's driving it. So we get those metrics from the third-party center. We analyze them and try to determine reasons. We further analyze based upon what they tell us. Is it operational in nature? Are they having problems understanding their bill? We try to analyze why they're calling. So we break things down into a number of metrics. Some of the metrics, as I said, that are most key, average call time, percent drop calls, those are shared on a quarterly basis with staff. And I believe Mr. Thomas's testimony, might be Mr. Cox's testimony, has a page from one of those reports that we submit to staff. So the generic, if I will, the overarching type metrics, we share those.
Thank you. Thank you, Judge.
Thank you. We have questions from Commissioner Kolkmeyer.
Thank you, Judge. I'm going to switch gears off of customer service and talk about fire protection just a little bit. How many of your systems have fire hydrants on them, your water systems?
I would venture to say, and Mr. Cox can talk about this, I would venture to say that it's 0.
Okay.
And let me explain why. If you read Mr. Cox's testimony, Missouri Department of Natural Resources states that drinking water systems are for that purpose. Primary consideration is drinking water. Secondary is providing any type of fire protection. So when a developer goes in, he knows the purpose of this is drinking water. You know what happens when you try and add fire protection to the cost? Mr. Cox has this analysis. At Terre de Lac, the people that were screaming the loudest about fire protection, we went through, based upon the Terre de Lac annual report, the number of feet of main there at a conservative value of $50 per linear foot. Putting in that fire protection, including changing hydrants, flushing hydrants to fire hydrants, would cost $12 million. Let's put that in perspective. I think the current rate base for Terre de Lac is $1 million. Current rate base to provide the primary consideration of drinking water is $1 million. To upgrade that to provide fire suppression, an additional $12 million. So given these small systems, it doesn't make sense for the initial developer or any acquirer to upgrade those to provide fire protection. It's just too costly. Where you see fire protection is where you see a more dense population. Certainly in Jeff City, it's easier. The number of customers per foot of main is much less. So, and it may be when those were initially installed at a place like Jeff City, there was discussions with the fire department and it was built in that fashion initially. But given the rural nature of our systems, given how few customers are there, given the fact that it would require upgrades of wells and storage tanks and mains and booster pumps and fire hydrants, $12 million at Terre de Lac.
Okay, thank you.
You're welcome.
And Commissioner Hahn.
Sorry, one more.
Sure.
Following up from Commissioner Holzman's line of inquiry about cost socialization, Your request was for single tariff pricing. Staff had a different request based on a regional model. I'm curious if the company has any kind of position. As you mentioned, Missouri American, much larger company, but worked toward single tariff pricing over a series of cases, as you mentioned, starting at 8 or even more, now down to 2. If the company has any other positions that they would bring forward as options the commission could consider.
Let me tackle that in multiple parts. First off, we did propose single tariff pricing. Single tariff pricing, especially for a company our size, more than Missouri American. Missouri American has 500,000 customers. You break them up into 5 districts, they still have 100,000 to socialize cost over. We have 9,000. You start breaking us up, you're losing all the economies of scale. So that's my first concern. Secondly, staff did not propose regional consolidation. In fact, if you look at Mr. Cox's rebuttal testimony, he shows a map of all of our systems, and you can see the way staff grouped them. It's all over the place. There is nothing regionalization about that. Instead, staff attempted to consolidate systems based, quote, on cost of service. Not cost of service on a per customer basis, but cost of service overall. So what that means, first off, is that all your larger systems, Terralac's our largest, will always be a large customer service, cost of service system. Just cost of service is just going to follow the amount of assets given the number of customers. So it's not regionalization on staff's part. It is a cost of service based model. The big problem with staff's recommendation, cost of service changes constantly. What they group together now, based on cost of service in this case, will change in the next case. When we make all those improvements at Terre de Lac that we still have to make, all of a sudden, Terre de Lac's cost of service is going up. When we make all the improvements at Glen Meadows that we hired or that we bought in December, now their cost of service is going up. So we get to the next case, we reshuffle everything. Cost of service is not a static number. So consolidating in their manner along those bases will constantly change. Heck, what they said was cost of service in their direct testimony has already changed. They've made a number of concessions and admitted errors on rate base for a lot of different systems. They didn't change it, but if they wanted to be true to their approach, they should have gone back based upon all their errors, recalculated customer service, and reshuffled them to do it properly. Other problem is, if you look at it, mechanically, they had errors. So even what they have grouped together doesn't make sense. Are we coming forward with an alternative? We hadn't planned to, because as I said, we have 9,000 customers. Let's call it 4,500 water, 4,500 sewer. If you try to break those up, you're losing all of your economies of scale. So more than, like I said, more than Missouri American, we need the economies of scale. Not we, we're going to get our money anyway. Our customers need those economies of scale. As I said, coming out of the last rate case to this one, Hillcrest is seeing rate reductions. What's driving those rate reductions? The consolidation that we proposed. What will drive for Port Perry, those customers that are mad here, what will drive their rate reductions in the next case? Those consolidations. If you split it up, that mitigation impact of consolidation is lost. There's a group, part of NARUC, called the National Regulatory Research Institute, NRRI. They put out lots of papers about this going back 20 years. Like I say, this big picture problem has been in existence for a long time. NRRI put out reports on this 20 years ago. They're quoted in Mr. Cox's testimony, but they talk about 20 years ago, the biggest thing about consolidation, rate mitigation, and it allows for the acquisition of small systems. So consolidation is huge here, and you will lose lots of benefits if you don't do it. Getting back to Missouri American, as I said, Missouri American is now 2 systems. The commission has said over and over and over again, we appreciate the benefits of consolidation. So if they appreciate those benefits, why is Missouri American at 2? Wasn't something the commission decided. General Assembly, you guys may remember this, instituted a mechanism for St. Louis County called an ISRIS. And so it's changed since, but given that ISRIS component that was just applicable to St. Louis County, the commission said it makes no sense to try to consolidate St. Louis County, who uses the ISRIS, with non-St. Louis County. So it wasn't the commission saying, we think 2 is good for consolidation. It was the commission saying, while we like consolidation, we recognize the statutory impediment. That's the only reason St. Louis County is where it is. And so the commission, in fact, has said that's applicable to water. The commission has made statements, and I don't know where it stands currently, but the commission has said in previous cases, we want all the Missouri American sewer systems consolidated into one. The commission's policy in a decade worth of orders is we want consolidation. We're trying to give it to you. First issue tomorrow, Mr. Cox will be testifying on that.
Okay. Any further commissioner questions? Thank you.
Thank you.
Thank you, Mr. Woodsmall. A quick announcement. I'm going to let staff off the hook. We're going to adjourn before opening statements for staff and OPC. My thinking here is we were going to adjourn in 10 minutes anyway to start discussing what our plans are this afternoon and tomorrow. And we need to allow the commissioners and our technical staff to move upstairs for the agenda session. So we are just 10 minutes early. Let's quickly determine when we are coming back so that the commissioners can start making their way upstairs. I was thinking 2 o'clock, but I want to make sure that we have enough time for staff to give their opening, for the Office of Public Counsel to give their opening, commissioner questions for those, and then hopefully our 2 issues. Would 2 o'clock work for everyone?
OPC does not oppose 2 o'clock.
Opposition from staff, Your Honor.
Problem, sir. Look forward to being able to speak with all of you.
Again, the reason we're considering this is because Evergy has a presentation and also we have the agenda session. I have heard 1:30. Maybe we'll split the difference at 1:45. 1:45. I apologize that it's not a round number. Excellent. 1:45. We are adjourned and in recess off the record.